Welcome, everyone. You are welcome to turn your video on if you'd like. This is one of our practice group meetings, so we would love to see people's faces if it's possible. If not, we totally understand, but we do encourage you to. And if you could take just a quick minute, like Benny has done and Erlan has done, and rename yourselves to include your firm. And if you don't know how to do that, you can just send me a quick message, but you hover over your own video or your name and click on the 3 dots, and there's an option for rename. And like I said, if you have an issue doing that, feel free to pop me a note. But for those of you who don't know me, I see a few new folks here tonight or this morning, wherever you are. World Law Group and I manage our practice and industry groups. And this is a meeting of the Tax and Private Wealth Group. We do a lot of these meetings, usually in the early morning for the Americas region, and we're trying to add a few in that are a little more time friendly for those folks who are in our Asia Pacific region. So this is one of our evening sessions so that we could accommodate those folks. But I'm going to go ahead and hand it over to who is the Asia co-chair of our Tax and Private Wealth Group, and she is with us from Singapore. Bak.
Hi, thanks so much, Hannah. Hi, everyone. Good morning, and like Benny says, good afternoon, good evening, depending on where you're from. Thanks for joining us today. We've got an interesting private wealth topic today. We're talking about mental capacity. And what we hope to do is that Benny Roshan, who hails from the US, will start off with what the position is in the US, and then I'll follow it up with what is the position in Singapore. And perhaps through the discussion, you can give some thought to what is your position in your country, and we can share a bit towards the end of the discussion. That would be quite useful for one and all. But to start with, I thought we can do a bit of an introduction so that we get to know each other slightly better. So as Hannah says, I'm from the firm of Wong Partnership based in Singapore. I head the Specialist and Private Wealth Practice Group here, which essentially means I cover a lot of the estate, succession, family office, that sort of work. And my practice comprises both contentious and non-contentious work as well. Right? So perhaps, Benny, you'd like to go next?
Yes, of course. Thank you, Bak. It is a pleasure to be here. Thank you for the kind words, and good evening from Los Angeles. I am a pure trust and estates litigator based in Los Angeles, and we litigate capacity issues all day long, every day here. I don't do any planning, and if you really want me to embarrass myself and cause a lot of damage, then you would ask me for some kind of tax information. So hopefully nobody on this group is ever going to do that. But I actually will be addressing strictly California, because in the US, probate, almost every state has its own probate code, and there are slight modifications, although California is the leader in the private wealth disputes, I would say, in the entire United States. So we see it, we litigate it, other states follow. We are oftentimes the model, I think, not only for the US, but probably other countries as well. So happy to be here. Thank you.
I'm just following how you guys appear on my screen. So I have Erlan next.
Hello, everyone. Nice meeting you. For those who I don't know yet, my name is Erlan. I'm a tax partner with Tozini Freire in Brazil. I handle both corporate issues and wealth issues. So I'm responsible for the wealth practice here in Brazil. Unfortunately, I'm not specialized in capacity issues as you many, but I will handle the usual tax work here. So that's it.
Thanks, Erlan. Next, I have Jose.
Hello, everyone. My name is Jose Valecillos. I'm from Damper in Venezuela. I'm a partner of the tax group in the firm, and I handle corporate tax matters as well as wealth planning and succession planning for Venezuelan clients.
Thanks so much, Jose. The next person I have on my screen is Ivy.
Hi, everyone. I'm Ivy from Vallet Reycaui Perez, Peru. I'm a senior associate in the firm. I specialize in taxation, so I see about everything, and also about private wealth management. So that's it. Nice meeting you.
Thanks so much, Ivy. Vanessa, would you like to go next?
Yes, my name is Vanessa Watanabe. I'm the tax partner in Vallet Reycaui Perez Abogados, Peru. I work with Ivy. He helps me a lot in private wealth management here in Peru. Our expertise is more in corporate tax, but now we are trying to develop our wealth management practice, and that's one of the reasons that we are here. Thank you. Nice
Thanks
to meet
so much, Vanessa. Puichi, would you like to go next?
Hi everyone, my name is Puichi. I'm from Shendalamore, Malaysia. I'm a tax partner and I mainly deal with tax litigation matters. Thank you. Nice meeting you all.
Thanks, Puichi. I have Hannah on next. Hannah, can you hear us?
I had muted on
Oh, sorry.
Sorry about that. Yes, so I'm Hannah with Hannah Shea with World Law Group, and I'm our Senior Manager of Business Development and Communications, and I work with our many practice and industry groups, tax and private wealth being one of those. Thanks, Bach.
Yeah, and Hannah is totally indispensable to our meetings all the time.
Thank you.
Okay, I next have Shinika.
Hi, everyone. I'm here to just support Benny. I'm not an attorney at the firm, but I'm the director of marketing at Greenberg Lusker, and yeah, just handle all of the firm's marketing and business development initiatives. Thank you.
Good to have you, Shinika. Karina, would you like to go next?
Yeah, sure. Thank you. I'm Karina Robledo from Santa Marina y Esteta. I work in Mexico City. I'm a tax counsel in Santa Marina.
Thanks, Karina.
Yes.
We next have Elvin Lim.
Hi, everyone. Hi, I'm Elvin. I'm from Singapore. I work with Bok Ing, Wong Partnership. And I also do work in the private wealth space. So some on the front end, the planning, the transactions, as well as on the disputes end. So the whole life cycle. I'm excited to join this discussion this morning.
Thanks, Elvin. And last but not least, we have Ian. Okay, maybe he stepped off for a while. Okay, we'll get Ian to introduce himself as soon as he's back. So with that, I would like to invite Benny to start the discussion this morning in relation to the state of litigation in California relating to mental capacity. Over to you, Benny.
Thank you very much. I hope you can all see my screen share because I'm not a tech savvy person, but I think I got it. Does everybody see that?
Yeah, Benny, and you can go to slideshow and then say present from beginning, first icon.
And then where, let me just see, present.
First icon on the left from beginning.
There we go. Okay. All right. So thank you. The hardest part of my presentation is over because I just figured that out.
No, Ben, sorry. I think you're sharing the other screen, so we're still
okay.
seeing the.
Okay,
I don't know if you want to reshare your.
So I'm actually sharing this screen. So why is it not doing it? Let's see. I guess I hadn't figured out the hardest part of my presentation. Okay, so I don't, Shanika, give me instructions, or maybe if you want to pull it up and share, if you want to do that, that would be awesome.
Yeah, I mean, you can go ahead and.
So Benny, down at bottom, see if the button at the bottom will work. So if you go where it says display settings and then it's the fourth icon over to your right, that looks,
okay.
Yeah, click on that and see what happens.
Did that work?
Yeah, so it must be your computer screen settings.
Because it's doing some weird thing. It's now showing me both. Okay, let's see something here.
That's okay. I mean, you can just go through it in this way. It's no big
Yeah,
deal.
you'll just have to click on each of the slides instead of using the forward forward arrow, but that's fine because we can see the slide perfect. I mean, it's large on the screen, so we can see it.
I mean, I've queued it so that I could scroll through it using my mouse. Okay, so hello everyone. I will be covering how competence, what I call capacity issues in California courts. So as you all know, my name is Benny. I chair the probate trusts and estates litigation group here at Greenberg Glusker. And I exclusively litigate, as I mentioned earlier. And I will be talking specifically today about how competence and capacity is assessed in California courts. And capacity and competence is determined differently depending on whether the impacted person is alive or deceased here in California, as I would imagine is handled in other jurisdictions as well. Capacity determination, while there are slight differences in terms of the evidentiary burdens of proof that you would need to show in court. And so I'll be briefly touching base on that, just so that you guys know in terms of just gauging or having a pain tolerance. My presentation is not going to be more than 15 minutes. So bear with me, as painful as it might be for some of you, who the idea of like going to court might just not be as fun as it is for me. Capacity litigation, what I call ex ante. So before a person is deceased, how do California courts, I'm talking about state courts, handle issues of capacity when they arise while the person is alive? And by way of providing some context, the way in which these issues present themselves when a person is alive is either through a contested conservatorship proceeding, or periodically through some type of elder abuse claim. And I don't know if anybody followed, for example, the Sumner Redstone saga. There, the two girlfriends and his daughter were at odds with one another, and so his capacity was litigated in probate court. And the reason why that was such a big deal was because the daughter for Sumner Redstone claimed that, the girlfriends, who were significantly younger than Sumner, were essentially taking advantage of a vulnerable adult who had lost capacity. And so that was a very interesting trial, and it obviously resulted in the daughter winning, and the two girlfriends, Manuela, and I don't remember the other girlfriend's name, were unceremoniously kicked out of Sumner Redstone's home. So how courts are typically, this is a very abbreviated summary for you guys, just sort of the highlights, what our courts look at, and that is treating physicians' reports and testimony. Very, very critical. So, you see physicians coming into court and they'll testify. I saw Sumner 2 days ago, 3 days ago. He is unable to make decisions for himself, and especially decisions that require very complex thinking. So, a multi phased estate plan comprising of many assets, businesses, real estate, you name it. Estate planning attorney declarations. A lot of the times, the older we get, the more contact we have with some of these people. So for example, our physicians, their estate planners, you know, a lot of our elderly clients, I mean, they're changing their estate plans very often. You know, oh, I want to change my trustee, I want to change the executor, you know, it sort of happens almost on a yearly basis. And so that all gives fodder to potential litigation because, you know, somebody could argue mom is vulnerable, dad is vulnerable, why did they make that change? And that change is not valid, essentially. This is also common, capacity determination by a qualified geriatric psychiatrist. So we will have, and that's sort of in the form of a dueling expert testimony in court. So we will get, for example, a doctor who will evaluate and will do like a multi-point, you know, assessment of the impacted person, and then we'll render a report, and that report is used in court. And oftentimes that capacity expert is called into court and they provide testimony. The final thing that is really, really interesting is that a lot of the judges in California courts, especially in Los Angeles, which happens to be the biggest state court in all of America, and so we're sort of the leaders in you know, the state court, I guess, environment. A lot of the judges call themselves super fiduciaries, or, you know, something along those lines, where they believe that they could they could supplant their own judgment for that of the evidence. And they a lot of the times, you know, judges are people, and so they'll just rule based on some kind of feeling or their own interpretation of what's going on about the situation. And so what the court will actually do, and a lot of judges love this, they will call into court the affected person and they'll ask questions and they'll evaluate all of the evidence. And the most recent example that comes to mind that was very interesting is, I don't know if you guys have followed the heir of the Walt Disney fortune, Brad Lund. The judge in that case, you know, basically made a comment from the bench and said something like, I'm going to appoint a guardian ad litem because, you know, I think that Brad Lund has Down syndrome, or, you know, yeah, Shanika, that's totally fine. You know, that actually resulted in Brad Lund suing that particular judge in federal court, because, you know, he argued that his United States constitutional rights were impacted by the judge exercising that super fiduciary role. So, you know, very, very, very interesting and contentious in our part of the world. Understanding how courts analyze these issues retrospectively may inform us. Anyway, so now we're going to move on to the next slide, and I'm going to talk about the most common capacity disputes that we see. So the next slide is going to be addressing that. And I call this capacity litigation ex post. Ex post is obviously when the person has died, and the issues of capacity are litigated utilizing what we call here a retrospective review of the decedent's medical records. So same kind of things happen. A lot of the times when you're doing a retrospective review, you do not have a contemporaneous assessment. You know, sometimes you do, sometimes you don't. And so what we're left with is, you know, it's a very ad hoc case by case basis, but we use everything about that person, their medical records, their meetings with their estate planners, you know, anything that we have pretty much to
Hi there. Good. Very well, thank you.
Hi Ian, you're not muted. So their decisional capacity is then determined retrospectively. It's not a perfect world, but that is the world in which we live in. And then the judge decides, based on the credibility of the evidence, whether or not a particular person had the capacity to execute a particular estate planning document that is obviously causing a dispute among the family members. And then next slide. is a note on conservatorships. So this is not a discussion on conservatorships, but what I will say, because it is relevant to all of our practices here, is that even the best late estate plan is not always sufficient to avoid conservatorships in California. What I will say is that, we have brilliant estate plans. I mean, the ones that I see, they're buttoned up. They have multiple components. They have a doctor's, assessment and everything. And the person makes and transfers their wealth using these very, elaborate and competent estate plans. And then what happens is the estate plan, the person loses capacity and they execute basically, I am no longer, like a resignation document, basically, in effect. And what will happen is that resignation document goes into a financial institution, so where the business's bank accounts are held. And where it gets evaluated is that on the first level, it gets evaluated not by the legal department, but by someone who is not really familiar with estate planning documents. And so they'll question this particular document, the succession document, and they'll say, well, we're not going to honor it, and you're going to have to go and get a court order. And then the only way to get a court order, of course, right, is, wait a minute, we have a valid power of attorney. Why wouldn't this be honored? It ends up getting filed with the court. And in one of my cases, I have the example, Alan Schwab conservatorship. Mr. Schwab, who is now deceased, lost capacity while he was, still had his business. He had a power of attorney that his wife held, and the bank in that case said, I'm sorry, but this is not sufficient. You're going to have to go and get a court order. And we ended up getting letters of conservatorship for Mrs. Schwab. And a final note that I'll say on this topic is that contested conservatorships become 100% about capacity. And the proposed conservatee, the person who's impacted, is entitled to a jury trial of his or her peers. So thinking of it from the standpoint of protracted litigation, cost of litigation, I mean, it really does become very, I want to say the word uncomfortable, but uncomfortable not in a sense of, in every sense, for the family members going through it, for the advisors, for the court and everything, because in California here, we are extremely backlogged and we don't go to trial any sooner than 2 years. So it's, that is a note on how capacity kind of comes into play. And then I think I have a couple more slides. If for those of you, and I feel like many of you on this call are sort of rule lovers and code lovers, this is a California code section that we deal with in terms of capacity. It's probate code section, California, probate code section 811, which walks you through what are the levels of capacity that the person has. And oftentimes it's on a sliding scale. It's not a one size fits all, and every case gets its fair day in court after 2 years of deciding whether a person has capacity ex ante or ex post had capacity. And then I think that was the last slide. I am happy to answer more questions. I intentionally kept that very brief so that you got a flavor of what's going on in California, but that's certainly, there's a lot more to it than that. Thank you, everyone.
Thanks, Benny. Would any one of you have any questions at this juncture, or you preserving your powder for later? Actually, Benny, just to raise a point, something for you to think about. It'll be interesting to know what are the evidence that the US courts put more emphasis on. For instance, in Singapore, the emphasis tends to be on the contemporaneous evidence relating to the livelihood and the circumstances and situation under which the person suffering from mental capacity, P, the emphasis in Singapore tend to be relating to that sort of evidence surrounding the person's livelihood. So maybe the evidence of the relative, the evidence of a friend and all that, as compared to evidence provided by doctors, medical
absolutely.
experts.
I'm happy to address that very briefly right now. And I'll tell you that, yes, we are very much in line with your courts on that topic. And we obviously have tiered evidence that the courts give priority, and top tier, top shelf is the contemporaneous assessment of the affected person by a trained geriatric psychiatrist who has gone through not only a mental like mini exam, but a full multi, like level exam. I think it's like the Folstein something like exam. And they go through all of that and they come up with a conclusion. I believe this person has decisional capacity to execute a will. I do not believe this person has decisional capacity to execute a trust.
Yeah. So that's the same position as Singapore, and the difficulty that creates for wealth planners and a lot of us lawyers or tax accountants dealing with the vulnerable adults is we have no certainty, because typically when we do planning, when we take instructions, we have the person in front of us, we do the assessment that we can, but we don't have the full information. And it used to be that in Singapore, at least, a lot of us, we would just send the vulnerable person to get a medical report or a medical cert to say that he's able to make decision. But as and when it's ever contested, that cert actually is not such great protection for the lawyers as we would have thought. I suppose it is probably the same situation for the other jurisdictions as well. So I'll just park that aside, think about it. What I'll do next is I will tell you a bit about the practice in Singapore, and then we can come back and discuss a bit more. Let me see if I'm doing this right. Okay, so I will just spend maybe 10, 15 minutes on the regime in Singapore, which I suspect it is going to be quite maybe a bit similar to that in the US, but definitely very similar to that in the UK. We kind of copied our Mental Capacity Act 2008 from the UK version and did some modification, adaptation of our own. So the Mental Capacity Act in Singapore is different from the previous regime we have. Previously, we have the Mental Disorder and Treatment Act, where you go to court for the court to declare whether a person has mental capacity or not. With the Mental Capacity Act, it's not a blanket declaration. The ability or the mental capacity of the person is time and decision specific. So you can have, for instance, patients with Alzheimer's. They may have better clarity of mind in the afternoon, but in the morning when they just wake up, they totally cannot decide even what to eat for breakfast, right? So in that kind of situation, if in the afternoon, they are able to make certain decisions, for instance, to execute a lasting power of attorney or even to do a will, then that act will still be considered valid and done when the person has mental capacity. So it's also decision specific. We take into account that a person may be able to decide who he wants to take care of her, but not the decision to make a will, for instance. Right? So it's that kind of new regime that we go into. Our test for the lack of mental capacity has two barrels. There's a functional element, whether the person has the ability to make decision, and there's a clinical element, whether there's an impairment or disturbance in the functioning of the brain or the mind. So both elements have to be satisfied. So the person has to be unable to make decision, meaning that they either cannot understand the information that's provided to them, they cannot retain the information because they're forgetful, they are not able to rationalize or use the information provided to them, they are not able to communicate the information. Plus, there is some sort of defect or disturbance in the functioning of their brain. Right? So in a lot of the mental capacity litigation in Singapore, undue influence is also a very big factor. Right? So it's almost a standard that when you go to court to dispute the mental capacity of a person, there would always be this undue influence that's in the background. And the Singapore courts have established that undue influence is quite a relevant factor when you're looking at whether the person has mental capacity to do an act. Right. So in the case of BUV and BUU in Singapore, the court essentially says that when the person is affected by undue influence, we have to further take into account whether the person knows that he's under undue influence, whether the person is vulnerable to undue influence, and whether if he or she is under the undue influence, whether he can get assistance. So those are the elements that the Singapore courts have looked into. Then I found this very interesting decision from the Cayman Court. This is from the Grand Court of the Cayman Island, Ray Poulton Family Trust. This one is very interesting because the settlor had 5 grown children from his first marriage. And then he's currently, I think, in his 80s, and he was staying with his second wife or mistress, right? So he had kind of occasional contact with 5 children, kind of like over Christmas and the big birthdays sort of thing. So after staying years with the second wife, what he did was he executed a deed and he removed all 5 children as beneficiaries from his family trust, right? So then the children were very upset, and they filed a litigation in the Cayman courts they took the position that the settlor did not have the mental capacity, or alternatively, the settlor was under the undue influence of the second wife. On the interesting thing is that when the settlor was assessed by various doctors and psychiatrists, everyone came to the conclusion that he had the mental capacity. He knew what was going on, and he did intend to disinherit the 5 children, right? Then the whole case turned on undue influence. It turned out that the second wife had been poisoning the settlor's mind. The second wife didn't tell the settlor that the 5 children had been trying to visit him and to meet with him and talk to him. The second wife also did not tell the settlor that she's been blocking the children from access to him. And the last straw where the courts were concerned was that the second wife used various lawyers and wealth planners to speak with the settlor, but all these lawyers and wealth planners just stated what the second wife wanted them to say. So to the court, that was very telling, right? So undue influence is a big factor when we are dealing with vulnerable adults as well. Okay. Then under the Act, our Act has mainly 2 sections, right? Our Act allows planning of a situation where the person loses mental capacity. So when a person still has mental capacity, they can execute a lasting power of attorney and appoint anybody that they want to take charge of their personal welfare or their property and affairs. Okay, and the main guiding principles that this person's appointed, we call them donees. The main guiding principles that they are under is that they have to act in the best interest of P, the vulnerable person. Then in cases where people fail to plan and the person has already lost some mental capacity, it is possible to go to court to make deputy applications to appoint deputies to act on their behalf. Okay, now because Singapore is quite a wealth hub, the common question that we were asked is generally whether a lasting power of attorney that's executed in, for instance, the UK, can it be used in Singapore, right? So this also applied to instances where the settlor has been declared mentally incapacitated. For instance, we had one case by the Mexico court. Now, the general approach in Singapore is that we only recognize the Singapore Order of Court. We only recognize the Singapore lasting power of attorney, right? The only exception is that we do have this vesting of assets, this provision in our Mental Capacity Act. And what this act says is that if a person, whether they are a donee or a deputy or conservator that's appointed by a court, a foreign court, and that person, the vulnerable person, has assets in Singapore, we can make an application to the Singapore court, and the Singapore court would vest all of P's assets in Singapore in the foreign conservator or the foreign deputy. So this provision has been quite useful. We had seen multiple applications under this where, for instance, high net worth individual, they could be domicile or resident in the US and UK, but they have private bank accounts in Singapore or properties in Singapore. So if there's an order from this overseas foreign court, we can bring it to the Singapore court, and the Singapore court will allow the vesting of all the Singapore assets in the deputy. right? Then in terms of foreign medical reports, our courts are a bit more conservative. We tend to make our own assessment. So VC and VVE is an interesting case. In this case, the donor, the P, had executed 2 lasting power of attorneys on the same day, one for UK and the other one for Singapore. Now, there were dispute as to whether P had the mental capacity when he executed both LPA, and the UK Office of Public Guardian did the investigation, and they came to the conclusion that the person had the mental capacity, right? Or was it did not have a mental capacity? But in either case, when the matter came to Singapore, the Singapore courts revisited the entire issue, and the statement from the Singapore courts was that the report from the UK OPG is just a reference document that the court will look at. It doesn't have conclusive or persuasive weight. So the difficulty that typically arises from this is that it essentially means that medical reports have to be obtained as to the position of P. So we have instances, for instance, in one of our case, the patient was in Belgium, and she had already been declared as mentally incapacitated by the Belgium court. The son wanted to move her to Singapore and also needed an order of court, a deputyship order to take care of the mother's interests. But in that kind of situation, the Singapore court will take notice of the fact that there's a Belgium order. The Singapore court will take notice of the fact that there are Belgium medical reports, but still that there may be a need for further review in Singapore to provide the necessary report in compliance of our practice direction here. So that can be some inconvenience for some high net worth clients who want to move over, right? So those are the usual common issues that we tend to encounter in the private wealth space when we deal with vulnerable adults. The other big chunk of issues arise out of trust document. Okay. Now, we would have thought that for trust documents, if the settlor had the mental capacity when the trust is set up, then we are good. But we notice that in practice, the other few issues that tend to arise is also the definition of incapacity that tends to appear in our trust document. So I've set out in my slides a couple of the variation that tends to appear in trust documents. So you can have provision where it says that incapacity is based on determination by a court of competent jurisdiction, or it can be determination by qualified professionals that are approved by trustee, or simply determined by trustee, or by certificates from qualified professionals. The difficulty is always that the trustees prefer some expert assessment that they can rely on, but they also do not want to be bound by the expert assessment. And a lot of the concern is, for instance, trustees sitting in Singapore, they don't know which are the proper doctors that they can rely on, for instance, in Brazil, in Malaysia, or in the US, right? So there's some hesitation to be totally bound by that sort of expert opinion. So they wanted some discretion, but they didn't want full discretion in case they get it wrong, right? So it is quite a difficult balance that we need to reach on this part. Then the other issues that arise in the trust context relates to when the settlor doesn't have mental capacity and is not able to exercise the various powers under the trust, or the protector doesn't have the mental capacity to give its consent under the trust. In Singapore, typically the question that would arise is whether in that kind of situation, the donee or the deputy that is appointed by the court or the LPA, whether they can step into the shoes of the settlor and protector. The general view tend to be that they cannot. It is not a power that is personal to the settlor or the protector. Then in relation to beneficiaries, the issues tend to be slightly more difficult, though it is more common as well. So it really, the main issue relating to beneficiaries is the giving of receipt, whether the beneficiaries, if they are mentally incapacitated, how are the trustees going to obtain proper legal receipt and discharge for the amounts paid? And then there are also other issues like, what if the guardian asks the trustee to pay the money due to the beneficiaries into joint account? How do we know that how would the trustees know that the money went towards the benefit of the beneficiaries as opposed to someone else? And how would the trustees discharge the duty of court, the duty to the trust, right? So these are just some of the issues that we face in Singapore, which I thought would be good to bring to your attention. And then we can always discuss around it, right? So that's what I have for today. Shall we open the floor to discussion? Anyone with any comments, any issues? We can discuss them.
Excellent. Yes, I think that if anyone wants to chime in here, sort of from their jurisdiction, if there's some interesting case that you have worked on or that's happening that you want to share, we want to encourage you to participate. And Bach, I will share the slides from both Benny and Bach for the presentation, since I know we have some issues with the slides, but I'll circulate those in an email after. But yes, if you have any, if you want to chime in on anything or chat about something specific to your jurisdiction, please, we welcome participation by anyone, Jose or Lon.
Well, for me, it was very interesting to hear about how this type of issues and matters are dealt with in California and in Singapore. And it gives us a broad idea, because mostly when we plan for Venezuelan high net worth individuals, usually we tend to go to other jurisdictions, right? Because at least the trusts are not widely used in Venezuela for planning, and most people, I don't know, and probably this is something that occurs in other countries in South America. We look to get these type of matters out of your jurisdiction many times for privacy more than tax planning. So, I wonder how, if we set up a trust, let's say in California or in Singapore, if that it's possible for a non-resident in those jurisdictions, if we have an issue about, mental capacity of that person, how are we going to litigate that in those jurisdictions? So, it's very interesting. So, I appreciate both of your ideas and taking the time and the opportunity for participating here.
Yeah.
I will say,
yeah.
Go ahead.
Go
sorry.
ahead, Ben. Yeah.
No,
So
I'll do it after you're done, because it's more like a fun thing.
okay. So I have encountered situations where trusts are set up not from Venezuela but from Mexico, right? So the Mexican settlor actually set up a trust. The trust is a Singapore trust and based in Singapore. The beneficiaries are his children that are, I think, located in various parts of the world. Then there are also two protectors, one from Mexico as well, and the other one from, I think, somewhere in the Middle East, right? As with the other case, the Potent case, the trust was set up about 20 years ago, and throughout these 20 years, the children grew up, the settlor became a widow, and he remarried, right? And the issue that arose was that the settlor came to us, and the settlor wanted to revoke the trust on the basis that he's of a certain age, the children are independent, he wanted his money back, the trust is not necessary anymore. Before we could act on it, we received notification from the protectors as well as children not to do so, because same position, they took the view that the settlor doesn't have mental capacity and that the settlor is under the undue influence of the new wife, right? And they even provided us with medical reports from quite an established hospital in Boston to say that, for about 2 to 3 years before that, the settlor has been suffering from Alzheimer's or other forms of lack of mental capacity, right? And the clause in the trust deed at a point in time provide that incapacity is to be determined by certificates from any two qualified professionals, without stating whether they should be from Mexico, from Singapore, or how they should be qualified. So we got 2 certificates written in Mexican. And when we Google translated, one was a clinic, one was a kind of like auxiliary sort of doctor, auxiliary practitioner, almost like a physiotherapist type. And the trustees are wondering, what do we do with this? Do we consider them to be qualified? And in any case, that the doctors are from Mexico, the settlor is in Mexico. So how do we even determine whether the settlor had mental capacity or not? And this was during the pandemic. So flying is not possible. Going to meet the settlor is not an option. So towards the end, I think we kind of decided that we need verification as to the qualification of the professionals. So we wrote to the equivalent of the medical council for some sort of verification. And we also set up a video interview with the settlor. The difficulty we had with the video interview was that after it was set up, the wife was forever hovering in the background. She was always just behind the settlor. So that gave us some difficulties as well. Right. So it will be interesting. I think at some point in time, we will probably need a determination from the Singapore courts as to what to do with the notification and whether the settlor had the mental capacity to try to revoke the trust. Over to you, Benny.
No, I was just going to say that just because we're, in Hollywood, capacity issues actually tangentially arose in the Britney Spears conservatorship. I don't know how many of you followed that Free Britney movement that was coming in hot in 2021. And that was sort of a saga that, lasted for like 13 years. The capacity point here that a lot of obviously the media just was not tuned into, and that I was very much like, oh my God, why isn't anybody talking about this? Is that capacity, as Bach was talking about, right, is that courts sometimes lose sight of the fact that it is supposed to be with respect to a specific decision in one moment in time. So what that means is it could be capacity to execute a contract, which is very sophisticated. We need the highest level of capacity for that. But there's capacity to wipe your own butt, which is not that high, right? So it's not a one size fits all. And I apologize for that crass example, but I have 2 children and it seems like potty humor is all over my household now. But circling back to Britney Spears, in the moment in time where a conservatorship was necessitated, that was back in 2008, she was postpartum. She was really at the height of her fame. And also, unfortunately, she just did not have that, whatever the cause of the breakdown, her mental breakdown was, she didn't have the space to deal with it privately. So it all played out, openly in the media. And what resulted was, obviously, she did not have probably the capacity to take care of herself in a lot of ways, not just the contractual way, but she ended up getting conserved. But a year later, and this is all obviously by the Netflix documentary and Hulu documentaries that came out in 2021, it revealed that pretty much a few months after she was conserved by a court, she regained her capacity. She came to, she started performing, she started signing contracts through her conservator, to perform in Las Vegas. I mean, she amassed something like $160 million in the period where it was very shortly after the letters of conservatorship were issued. So the interesting and odd thing about that was no court, and shame on the Los Angeles Superior Court and the people that were overseeing this, but nobody ever asked the question, wait a minute, her capacity, what's the assessment now? Does she have now the decisional capacity to not be conserved? Should we terminate this? Should we? The gravy train kept coming, and her own lawyer and everybody just got into that ring of feeding off of her, right? While completely ignoring the standards that we as officers of the court, as the people that as advocates for our clients we're always asking that question. So anyway, that was just my fun comment about capacity issues coming up in the celebrity world.
Karina, what is the position like in your country? How do you deal with lack of mental capacity?
Well, in Mexico, there has to be a resolution issued by a judge stating that you are or that any person has incapacity to perform the activities, but there has to be a resolution. So you cannot just say that you have a kid and well, a kid is different because you are in that case the parent, but for example, for if my mom has a problem, then I have to submit a request. And if for example she has, or if she has to execute an agreement, then I have to file this petition before a civil judge, and he or she will have to confirm if my mom is or not. What I have seen, I'm not a civil lawyer, but what I have seen is that you, yes, indeed, require proof to demonstrate that that person cannot perform the work or cannot decide, and you need, yes, the proof of the a specialist saying that you that person cannot take their own decisions. And I think that for your case, because you were concerned on who is the if a practitioner is or not a qualified person, I will say that in Mexico, and I think in all countries, you have to be authorized, or you have a specific number to be authorized to be, for example, a physician or any type of, or a psychologist. You have a number, like an ID number, and it's in that way, supposedly that person is a qualified person to provide that, for example, that statement. And also, and what I know also is that the judge has its own, for example, psychologist to know if to determine if that person is or not able to take their own decisions, its own decision.
So the medical expert can be appointed by the court.
Yeah, they can be either two ways, either by the court or by the person that is filing for that incapacity.
Is there a preference for the training of the doctor? For instance, in Singapore, that there is a general thinking that in the court jurisprudence that psychiatrists are most suited to assess mental capacity, and then maybe the neurologist as well. Then everybody else, every other kind of doctors with other training tend to fall behind. Do you guys have the same experience from your courts?
I think that they will have the same. I think that they don't have preference. I can check, but I think in order to be let's say a psychologist of the court, you have to be authorized by the court. So you cannot, yes, they have to be prepared and have to file some exams to be approved as a specialist psychologist for the court.
Yeah, it's same in Brazil. The specialist is indicated by the judge, and the judge decides whether or not he or she is a specialist. So it's an indication by the judge, and it's typically a neurologist or a psychiatrist. So it's one of them.
Quite similar. Can I ask you?
Yeah, I would say there's a preference here for a neurologist. So, yeah.
Yeah, typically because these are the specialists that look into your brain, so I suppose they're more suited. Yeah. Can I check with you, Alan? I gather from Benny that the power of attorney can survive incapacity and I think even death. For Singapore, no, not death, just incapacity. Okay, so for Singapore, our power of attorney, the usual ones that we do, they will stop to have any effect once the person loses mental capacity or the person dies. And only the lasting power of attorney can have effect when the person loses mental capacity. What is the situation like for power of attorney in Brazil? Do they survive incapacity as well?
No, they don't. They don't. But I mean, the incapacity should be declared by the judge. So it's the same in Mexico. So it's, I mean, the judge should declare that the power of attorney is not effective anymore. So it's, but as I mean, I share the same impression of Jose. Whenever we have to deal with incapacity from settlers or beneficiaries, we always go to the trusts or U.S. instruments, because I mean our legislation is not prepared for that. We have, I mean, in Brazil we're trying to incorporate a concept similar to a trust. It's called fiducia. It's a contract similar to a trust, but yet I mean our succession law and is not prepared for those incapacity issues as the U.S. it is, for example. So when we have incapacity of beneficiaries or of the settler, we go through US trust planning. Also.
I see. Ivy, is that your experience as well?
Yes, same here in Peru.
Yeah.
Yeah.
Similar
we don't
to
have like
Brazil.
any sophisticated law. So when we have to constitute a trust, also we try to do it in the States or in another jurisdiction.
Okay. I think we are almost there on time, Hannah. Anyone else have other questions before we close this session? So are we good, Hannah?
I think we're good, but I did just want to say thank you all for joining us this evening or this morning, whatever time it is for you. And if there is, this group tries to meet 4 to 5 times per year. If there is another topic that you're interested in, sort of having one of these roundtable discussions on, or that is interesting and unique in your jurisdiction, please do not hesitate to reach out to me and let me know, and I'm happy to get you on an agenda.
Yeah, actually, I'm hoping that the next topic, we should probably do a tax topic. So we have quite a number of tax practitioners on this call. If you have an interesting topic, please do email to Hannah and we can work on it. Okay, thanks so much, everyone.
Let me see. Those dates are already on the calendar, so you'll find them on the website, June 28th. And then we have another one, September 27th. And for anyone that is attending the IFA Congress in Cancun, which is in the fall, I believe, we are working with with Santa Marina Esteta, Karina with your firm, to host something there. So we do plan to get together in person for those of you who are attending that conference.
How do I go to that conference?
I love that. That sounds fun, no?
I'm willing to learn tax, just for my own educational purposes, but not to impart it.
Yeah, this one is highly expected because it was postponed.
Oh, yes, and it's Cancun.
It was supposed to be in 2020.
Wait a minute, conference, Cancun. I don't care. I can be learning about anything. I'll go.
I take the opportunity because there's the regional meeting also coming up in May in Ecuador, in Quito. So if any of you are planning to go, let me know. I'll be there also.
Thank you, Jose.
Can you send me an email on that? And what I'll do is I'll send an email out to the group and see if there's anyone else. I mean, I'm sure there'll be, even if it's just a handful, I'd be happy to circulate that and find out who's attending.
I will.
Just don't plan anything for Los Angeles because I have like zero interest in seeing more.
Nothing there, right?
Thank you so much. I had so much fun. I enjoyed everyone. So I appreciate just getting the opportunity to meet everyone.